Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-5308, American Federation of Government Employees, National Council of HED Locals, Council 222, AFL-CIO, versus Federal Labor Relations Authority and Susan Swig Brennan in her official capacity as Chairman of the Federal Labor Relations Authority, appellants. Mr. Tso for the appellants, Mr. Grajales for the appellee.
Good morning.
Good morning. Good morning, Your Honors. May it please the court. I'm Tso for the FLRA. The case presented here is about LEADM jurisdiction, which this court has repeatedly said is a very narrow basis for the district court to review agency action. Only in circumstances when there's extreme agency error and where the agency has committed ultra-virus action so plainly beyond the bounds of its statutory authority to warrant intervention by district court under 1331. Now, this case concerns pretty much exactly the opposite, the type of case that warrants LEADM jurisdiction. In fact, in this case, the agency tried to correct an error to ensure that the entire case before it was within statutory bounds. The case presented to the FLRA exceeded the statutory limits by intruding upon classification matters, which from its origin in the statute that created FLRA specifically took away from the FLRA's jurisdiction classification matters and gave it to sister agencies in the OPM and MSPB, as we described in the briefs. Now, instead of going to these alternative agencies, it presented this case about classification to the FLRA. And yes, the case went on for several years, but eventually, when it reached the FLRA in the most recent instance, it looked at the case and saw that arbitrator acted beyond the statutory limits. And that is not in dispute before the appeal. The union did not dispute that, in fact, the classification issue was part of the case, integral to the case, and therefore the FLRA was clearly correct in correcting the arbitrators exceeding statutory limitations. So we see this case very similar to Middleman, which in fact this court has said cannot be an ultra-virus case because the agency took pains to limit itself to fall within the statutory limits.
Where does the authority get power to alter an award?
So I think it's sourced in two different areas. One is 7122, which says concerning the award, it allows the authority, when an arbitration award is presented to it, to issue orders necessary to concerning the award. And the award here was a culmination of several intermediate awards that occurred over the years. And so when it says concerning the award, within that, it was necessary to correct the ultra-virus actions that were void because the arbitrator exceeded statutory limits.
7122 starts with subsection A,
yes.
And it says, if upon review, the authority finds so-and-so, then it may take such action. And then after that comes B. And the very next sentence says, if no exception is filed during the 30-day period, then the award is final and binding. So it seems like the authority has no power to do anything if no exception has been filed for 30 days.
Well, you have to read 7122 along with the provision which actually describes the powers and the extent of powers the authority was given by Congress, which was 7105. So I think we have to read it in parallel and context. If you look at 7105, which is described as the powers of the authority, in H, it talks about resolving exceptions according to 7122, but then it goes on in I, says, and any necessary and appropriate actions to administer the statute, which differentiates this from several other cases. For example,
what's the point of the 30-day limit if the authority can go back and alter any award at once in the past?
Well, this is In this situation is quite different from a typical situation when there's an award that comes up that resolves all of the issues in the case. I think when the FLRA looks at a particular award, it looks at the entire case which is presented to the FLRA, not necessarily single pieces of an award.
Can I give you a hypothetical? What if there was one award and it said, this will be implemented over the course of the next 30 years. There was no dispute for the first 29 years. And then some dispute arose about implementation. 29 years worth of actions have been taken. And the authority decides, we think that first award was invalid. So we're going to vacate the award from 29 years ago and all of the actions that we've ordered since then. Could it do that?
Yes, under limited circumstances. So we're not talking about situations where it goes back and looks at merits of awards. Here, we're talking about trying to ensure that the statutory limits are imposed, because from the design, congressional design, it was not allowing arbitrations to reach these issues.
Something like that happens all the time in institutional cases where there's an injunction outstanding. The injunction is final and binding, but for example, in school desegregation cases and prison litigation cases, it keeps getting adjusted and adjusted and adjusted, sometimes broader, sometimes narrower, and it may be over 20 years or 30 years. And so the idea that it's final and binding means it's not final and binding on the court that issued the injunction. It's final and binding on the people that are subject to the injunction. And so it can always be modified, and actually can, if there's an appeal at any point there's a Supreme Court case that details all this. I won't bother with it. It's called RUFO, R-U-F-O. I don't have the citation on it handy. The analogy to me is right on point. So.
Exactly, Judge Randolph. In fact, there's a case from 1983 from this court, Office of Professional Workers versus WMATA, which makes the exact same point, which it says, in a similar situation, it read a statute with final and binding award, and it said that has nothing to do with judicial review. That all that has to do with is the party's compliance while judicial review is ongoing. And so it is sometimes unjust. It may be prejudicial. And Christensen versus Colt, the Supreme Court says, enforcing jurisdictional boundaries sometimes will cause prejudice, but that's what the authority is bound to do under the congressional design. And this is particularly clear when we talk about judicial preclusion, which is another basis for why leadem jurisdiction cannot apply here.
What if there was a habeas statute that looked different than current EDPA, and it said once a conviction is final, the prisoner has 1 year to file a habeas petition, and if the prisoner doesn't file the habeas petition, that conviction cannot be vacated. Period, full stop, no exceptions. Do you think that a court could come in 30 years later and vacate the conviction?
Well, first of all, the habeas petition, I think it's a petition for it's a recognized petition to the courts, right, for releasing of prisoners. Here we're talking about arbitration decisions that are final and binding, that are before judicial review. So in this circumstance, when we look at the Office of Professional Workers case, the court was pretty clear that the congressional history behind final and binding language in arbitration context between two private parties means that it is applicable to the parties themselves to prevent strikes and lockouts, to maintain labor peace while the judicial review is ongoing. And under the congressional design, the FLRA was the first step in that judicial review process. And so it's what this court said in Scobie was quite clear that Congress wanted FLRA to have full sort of authority not in unfair labor practice case, but a regular arbitration case, as presented here, full authority to decide those cases without further judicial review. And that is why the second prong, in addition to the final and binding language not being a clear mandatory requirement, the second prong also applies in that this court in Wagner, Loy, Scobie repeatedly has said that there is no jurisdiction of this of the federal courts.
Don't forget customs service.
Customs service, yes. Yes, they're just repeated sort of language, including Scobie saying it's a plain language, and Loy, Judge Randolph's opinion in Loy, basically saying there is no judicial review of these arbitration awards. And yes.
Can I get your thoughts on this theory of the case? The authority does not have the power to vacate I think it was a 2012 award, the award that preceded summary number 1.
Okay.
But if today's authority believes that that 2012 award was valid, there was no jurisdiction, then it can treat it as a nullity. So the authority going forward can issue decisions that treat it as a nullity. But what it can't do is it can't go back in time and vacate that 2012 award. So the parties are bound by the 2012 award, except to the extent that future orders from the authority tell them to do things in conflict with the award. And maybe future orders from the authority could tell them to do things in conflict with the award, because in the eyes of the authority, the award was issued without jurisdiction. How does that sound?
So that is suggesting the case in Nicholson, which does say FLRA already has the authority to not enforce awards that it views are nullities. So yes, we agree that that is a possibility, but it seems.
Would that be good enough?
Well, for a direct review to prevent having the parties to, again, having to go in the court and go through the entire process, it seems to me that it's favorable to have a direct review situation when there's a case right before the FLRA to enact the same effect instead of waiting for the parties then to enforce the award and then telling them that they're.
We never get to that if judicial review is precluded.
Yes, Your Honor.
Right? And that's what you were talking about.
Yes.
Yeah.
So there's essentially 3 prongs to lead them. I think the plaintiff doesn't satisfy the burden on any of the 3 prongs. And so if you don't think it's favorable on one prong, I think the other 2 prongs do also prevent. So I think my time's up. Thank you, Your Honor.
We'll give you some time on rebuttal.
Okay, thank you.
May it please the court, Andy Grajales for the union. The problem with what the FLRA is asserting here is that it has absolutely no limiting principle. They can act prospectively, but nothing in their delegated powers gives them the power to rewrite history.
So are you saying that the theory I floated you would be on board with? And are you saying that the theory I floated in my last question to opposing counsel is an approach to the case that you would be on board with? And just to be clear what I think it would look like, we would rule for you in this court. Right? We would reverse the district court's we would rule for you in this court. We would affirm the district court's granting of your summary judgment motion, because what you asked for was for the district court to vacate the authority's vacatur of the previous awards.
Correct.
Okay? So far it sounds like you're winning.
We asked for a vacator of
But-
HUD 8 and HUD 9.
So far it sounds like you're winning,
Yeah.
but and that would be nice for you, because maybe it would mean that maybe it would mean that satisfied obligations.
Well, it would
cannot be-
vindicate a right that the union has to binding arbitration. Because let's not forget that this issue, the issue here
But before
is
you-
that the authority already decided the legal question of whether the grievance concerned classification, found that it did not.
But before you get off track, let me tell you what I think you would not maybe like about this approach is that the authority here would not be obligated to enforce outstanding obligations, because those obligations would flow from an award that lacked jurisdiction.
So we would argue that the correct approach, if the court were to side with us, would be to affirm the district court, vacate HUD 8 and HUD 9, but remand to the authority for reconsideration of the 10th summary in light of any findings that this court would make. And so in answer to your question, it's a hypothetical of whether some future remedy would violate some other portion of the statute. But that would only apply to the exceptions that were in front of the authority. They would have to be in front of the authority. And the issue here is twofold. The authority had already made a legal determination that the grievance did not concern classification. So the injunction analogy that Your Honor raised isn't quite right, with due respect, because it's more as if in Brown versus Board of Education, the Supreme Court made a legal conclusion of a constitutional violation. That legal conclusion remained the same and it bound those parties, certain. But whether implementation in the future would change depended on whether or not there was a live case in controversy.
It's not just Brown, it's a whole series of cases. Let me ask you something. You agree, do you not, that under section, was it 7123, that our court would not have jurisdiction if you filed your action in our court?
In this court, well, Leadham has to proceed in the district
No,
court.
I'm not. If you filed your action for judicial review of the FLRA arbitration decision in our court, we wouldn't have jurisdiction.
That would be the premise of the case, and that's why we filed in district court. But to be clear,
The answer, wait a minute. The answer is yes, we would not have jurisdiction.
if it were filed as an original matter in this court, that's
Now,
correct.
If we don't have jurisdiction and all the cases that the counsel for the FLRA cited, we don't have jurisdiction, judicial review is precluded, then how can it be that we have jurisdiction to decide this case?
Because they're
in
talking,
this case, we have to conduct judicial review of the FLRA decision. And Congress told us we can't do that.
Your Honor, it's because it's apples and oranges. All of the cases that they cite to are inapposite. To begin with, this court decided in Griffith that Leadham review is available for this purpose when a party is bringing a challenge to a violation so severe that the authority has arrogated to itself a power that the statute does not give it. That case, which is the case here, belongs in the district
We're
court.
arrogating to ourselves a power the statute doesn't give us, namely
Not,
to review an arbitration decision that you've brought to us now, that's brought to us now on appeal.
well, not at all, Your Honor.
That situation did not exist in Leadham. In Leadham, there was no bar on appellate review, no bar of judicial review on appeal.
Well, so if
But
we,
there is here. And so the system that's being set up is that we don't have jurisdiction to decide this case, but the district court does. I mean, that's basically what you're arguing here.
that's what this court has already decided in Griffith at 490 of that opinion. That's exactly what Griffith says, and Griffith is not dicta. This court, when it makes a finding, is not speaking in terms of dicta. It's speaking in terms of a finding. And we know that because in the very same sentence, this court says, we find that the statute leaves the door ajar for a Leadham ultra vires claim. The court then goes on in Griffith to say, but they haven't met the standard in that particular case.
Was Griffith under 7123?
Yes, Griffith is under this statute. So Griffith controls the question of whether or not Leadham is available at all. And in any event, if you look at 7123, preclusion is clearly implied. It's not expressed. When I agreed with you earlier, that's because we're talking about run-of-the-mill cases that don't rise to the level, that jurisdictional dimension.
Well, I want to ask you
required by
about that. Do you realize that there's a bar in the Administrative Procedure Act under 701, and it says that if a statute precludes judicial review, the APA doesn't apply. You're familiar with that, I'm sure, right?
Certainly.
Yeah. Do you realize that the original bill said if a statute does not expressly preclude judicial review, then the APA does not apply? And the word expressly was excised from the statute. And the reason for that is that judicial decisions can determine whether there's a preclusion of judicial review. And we have half a dozen of them that hold just that with respect to analogies to this case.
Well, again, Your Honor, we don't believe that the court has ever held that leadem is unavailable under the statute. This court has consistently held that leadem is available. It has looked very cautiously and hard at particular claims. And we invite the court to do that here because we believe we meet the standard, but leadem is certainly available. I believe I may be over my time. I would just like to close with, if this was a power that the statute gave them.
I have a question along the lines of your answers to Judge Randolph. Leadem and the way we've interpreted it as a court distinguishes between express and implied jurisdiction stripping or preclusion. And I mean, what is the difference between express and implied?
The difference is clear. The difference is if you look at the MCOR case, it says there will be no judicial review. The Fiscal Responsibility Act of 2023 says no determination, action, et cetera, shall be subject to judicial review. That's express preclusion. There's none of that language here.
Between and kind of action and omission, and that line is always pretty blurry.
But that's
almost always phrase an omission as an action.
If we go back and we think about the considerations that underpin leadem, that's a real distinction with a difference, because agencies ab initio are creatures of delegated authority. And so that's what leadem is saying, is there must be review when an agency so violates its statute, where its violation is so severe that it takes unto itself a power it doesn't have. It arrogates power it doesn't have. There must be review. And that review proceeds in the district court. And the FLRA doesn't have that power. Their argument with respect to 7122A, they read the word concerning, they divorce it from the rest of the statute, the rest of the subsection. And in 7105, that section begins with a limitation. That can't be a plenary grant of power to the authority. It can't be, because it begins with a limitation, and that limitation is subject in accordance with this chapter. And even the specific subsection they rely on that gives the authority the power to take necessary and appropriate or proper and appropriate actions, it can't be appropriate if what they do violates another section of the statute. So the powers that they claim they have under the statute don't give them the power that they sought to exercise in this case. And again, the local 446 case, all of those cases that they rely on are totally inapposite. Local 446 involved a separate statute, and it was a ULP, and it actually, the determination by the undersecretary of the VA in that case happened much later in time, and that's what led to that decision. And
Do you agree with your friend on the other side that the arbitrator's decision was ultra-virus to the extent that it concerns classification?
no, and I'd also point out that's not a concession we make. We don't believe that's a fair reading of our brief, but also it's not a fair construction of the record. If you go back to Joint Appendix 759 in the union's response to the authority's amended statement of facts, we say that the grievance did not involve classification. So that's not a concession we make.
Why doesn't it?
Because if we go, it's a promotion grievance about whether or not individuals were denied promotion potential into previously classified position. And that's why. And that's what the authority found in HUD 2. They resolved that. And the authority has been reviewing the remedy. It's not actually a fair construction to say the authority never reviewed the remedy. HUD 3, HUD 4, HUD 6, those are authority decisions, final and binding authority decisions, where the authority upheld it. And in HUD 3, where the authority says the agency below HUD waived its defenses or its arguments on exceptions, let's remember that how that occurred was in HUD 2. It was the FLRA that remanded to the parties for resubmission to the arbitrator absent settlement. That's all that the union did. They didn't settle. They followed the authority's orders. So that's where that power came. So no, we don't agree.
How do you interpret the following language from opinions of our court? That we have recognized an arbitrator's award is absolutely immune from judicial review. Or in any event, the authority is the final stop. Or the service here committed or once the authority determines that the service has not committed an unfair labor practice, that's the end of the line.
Again, Your Honor, we would argue that's apples and oranges. Certainly,
The court
in
was
fact,
wrong in stating it that way?
no, it's what was under review that is different from what was under review here. Let's recall, actually, those cases help us because what we are arguing promotes the finality of arbitration awards, which this court has said in a variety of cases is what the statute intended. We're trying to get the benefit of the binding arbitration, the right that the statute gives us that the authority took
Griffith
away.
was a due process case, wasn't it?
No, Griffith had a variety of claims in it. There was a statutory claim. That was the lead-in claim that was reviewed, but ultimately
But
rejected.
it was a due process claim.
That's what the court reviewed after going through
Yeah.
lead-in. It was a constitutional claim. There were multiple claims in Griffith. But in closing, if this was a power that the authority had to go back and rewrite history, to unring a bell that's already been rung, we would have seen some evidence of that in their last close to 50 years of decisions. And it's not there because they don't have that. Thank you. Yes, folks. We ask for affirmance.
Start where opposing counsel left off. Has the authority ever done this?
So the authority has, in Nicholson, is probably the closest in which we've said that there is no longer final and binding. You're trying to enforce a void award that went outside of its jurisdictional bounds.
Did the authority in Nicholson purport to vacate the original award?
It didn't use the word vacature because at that point it was an enforcement action already. So it was in a different procedural posture. But I would like to go back.
Maybe another way of putting it is, did it attempt to reverse satisfied obligations?
I think what it did was exactly what Your Honor said, was treated as a nullity. So it didn't create, yes. But I think you have to go back and look at 7122 as a matter of statutory interpretation.
We could affirm the district court here and still leave open the possibility that you, the authority, could treat the 2012 award and summaries 1 through 9 as nullities. We could leave open that possibility.
You can leave open that possibility, but I think reading 7122 closely, I think will allow for direct review of these. And let me just point out that it says recommendations too, and it also allows FLRA to remand back to the arbitrator. So it seems like it doesn't make sense when you can remand and make recommendations. You can't in a subsequent authority decisions when this case comes up again to go back and vacate awards that went outside the bounds of those recommendations and remands. And it happened here.
I want to ask you a clarification. If the FLRA did not vacate other than the summary 10 or whatever, right? Then how would the union enforce the arbitrator's previous decisions?
Right, we believe it'll be almost impossible because they're all accumulation, they're all related to each other.
Well, they would insist on compliance by HUD. HUD would refuse because the orders were nullities. Then the union would file an unfair labor practice charge, right? And the precedent is that the arbitrator didn't have jurisdiction, so they would lose.
Yeah. So, I mean, it goes back to a simple principle that people who act outside in ultra-virus ways, like the arbitrator did in these previous summaries, their decisions are void, not voidable. So there were nullities from the beginning. And so it's hard to allow just for the enforcement action. I think in a direct review.
I think that makes a lot of sense. Doesn't what Judge Randolph suggests is you might lose the battle in terms of whether we affirm the district court. But you can still win the war. You can still refuse to enforce things you think ought not be enforced. And at the end of the day, pragmatically, even if we affirm the district court, you can still get your way.
I understand. For this case, yes, but I want to preserve the ability to correct remand, arbitrations on remand, arbitrations that were recommended, arbitrations that were on interlocutory review, for example. We have to go back and can vacate awards when arbitrators went off the rails after remand, for example. But I just want to make one last point in conclusion that Griffith, it was about a constitutional claim. I think the operative and governing standard should be MCOR, which is significantly different from the Griffith standard, which was issued before the MCOR Supreme Court decision. So, thank you, Your Honor.
Thank you. We'll take the case under advisement.
Case number 22-1757, Apprio Inc. versus Neil Zaccari, appellant. Mr. Keenan for the appellant, Mr. Hutchins for the appellee.
Morning, Mr. Keenan. We'll hear from you.
Thank you, Your Honor. Good morning, and may it please the court. Gregory Keenan, appearing on behalf of Neil Zaccari. There are two rights-granting contract provisions at issue in this appeal. First, there's Section 2.2's licensing provision. But importantly, Section 2.2's non-exclusive license cannot help Apprio's claim for a transfer of copyright ownership. That's because a non-exclusive license cannot transfer copyright ownership by the plain text of the Copyright Act. As such, nothing in Section 2.2 can establish a transfer of copyright ownership here. Second, there's Section 2.3's assignment provision, but critically, Section 2.3's assignment provision only applies to copyright material made, quote, during the period of my service. In other words, during the period of Mr. Zaccari's employment. As such, Section 2.3 does not transfer any copyright in any software that Mr. Zaccari created before his employment, such as the underlying code that was created in 2008, roughly 7 years before his employment began.
But in his copyright application, he said that the invention, so to speak, was created in 2016, which was during his employment, right? That's what he said, right?
He registered it in 2016 and didn't identify it as a derivative work. That's right. But importantly, copyright registration doesn't set the parameters for copyright protection under the Supreme Court.
Then doesn't the application ask when the work was created?
I believe it asked when he registered it, and it asked if it was based on prior content, which he didn't flag it as a derivative work. That's true.
So if he did not flag it as a derivative work, then how is it? And I believe that there were requests for admissions,
Mhm.
which are binding. That's the
Mhm.
whole purpose of them, right?
Yes, Your Honor.
So that we can narrow the issues for discovery in a civil case.
Mhm.
So the request for admissions responses identified the work as being created in 2016, right?
It requested an admission that it wasn't derivative work. Can I quickly answer just regarding the registration and then directly address the?
Sure.
Okay, so importantly, the Copyright Act itself clarifies in section 408C1 that the administrative classification of the work has, quote, no significance with respect to the subject matter of the copyright or any of the exclusive rights protected by the title. And that's because copyright, even though we register them very often, as the Supreme Court has made clear in the Fourth Estate decision, copyright protection, it is granted immediately upon creation, whether or not you ever go and register anything.
I understand that, but I thought that the application nonetheless asked the question of when the work was created.
Well,
Am I wrong about that?
Be honest, I don't know off the top of my head if it asked when it was created as opposed to if it was based off prior things, but even if it were, and 411B2 makes clear that a certificate of registration satisfies requirements of this section, regardless of whether the certificate contains any inaccurate information. So determining the scope of protection based off of information in the registration, well, I think a natural instinct, just as a matter of statute, probably isn't the proper way to determine the scope of protection. And that's again, in part because if Mr. Zaccari created the work in 2008, which he did create the base code, there's record evidence that he created a base code in 2008. The moment he does that, he receives protection into it, whether or not he registers anything with the Copyright Office at all. As to the admission itself, the admission was whether or not the edited code was a derivative work. There's two answers to that. Our first answer would be that derivative work is a defined term under the Copyright Act. So that's a purely legal conclusion, we would argue. Because the admission said, admit that the software is not a derivative work. The statute lays out that derivative work is a work based off of pre-existing material. And the statute also makes clear that any copyright in a derivative work wouldn't extend to the underlying pre-existing material. In the alternative, even if we completely accepted the fact, let's say we were bound with this admission, despite the fact that we think it's a legal admission as opposed to a factual admission or a factual admission leading to a legal admission, that still wouldn't change the fact that by operation of the Copyright Act, the provisions of section 2.2 and 2.3 still wouldn't give protection to that underlying material, because the only provision that would be affected by it being a derivative work would be section 103, which says that a derivative work protection doesn't extend to the underlying material, but there's also other provisions of the Copyright Act that don't require a work being a derivative work that clarify that you're not going to get the underlying material. So section 102A's originality requirement, for example, it's table stakes in copyright that you only get protection for what's called an original work or original components of a work. An original means not copied. So we know that he created work in 2008. We know that there was copying from that work into the new work. Even if we were stuck with the admission that it's not a derivative work, that doesn't change the fact that anything that's transferred in that edited code, it just can't give exclusive copyright to the elements that are copied and not original. And that's a matter not just of statute, as the Supreme Court clarified in Feist. That's a constitutional mandate. The Copyright Act and the Intellectual Property Clause limit the ability to protect writings to original materials. And so to the degree there was a transfer, and section 2.2 and 2.3 of the contract say, it's not going to transfer anything prior to the employment. The only portions of the work they're going to transfer over are the new works, not based off of the underlying work. And that's not just because of those provisions, but it's also because the copyright in that is not going to grant an exclusive copyright ownership in anything that was copied or not original from any other.
I'm not sure I understand where that gets you, because the fight here isn't about whether or not he can use or retain copies of the software as it was written in 2008, right?
That's right.
So what difference does it make if indeed he retains the copyright to the version that he wrote at that time?
I think it goes a step further, Your Honor. It's that not just does he retain that copyright, but the transfer of the subsequent copyright would only give an exclusive ownership right in those portions of the work that were original, that weren't created. So essentially, the primary error that just respectfully shouldn't be affirmed here is that the district court below said each and every portion of the edited code, was granted to Apprio, and that doesn't make sense.
I don't see how that argument makes sense, in that the revised code, the edited code, can't work without what came before it. I mean, it all works together. Revised code builds on the old code. So you're trying to say that Apprio only got a copyright to, half a code, so to speak, the new half, but even if it needs the other half to work, it doesn't have a copyright to that half. I don't understand your argument.
Importantly, not exclusive copyright ownership. Remember, section 2.2 of the contract talks about a license, a non-exclusive license. So they might have an argument that they could make a licensed use of it. That's not what they asked below. They asked for a termination that they were the exclusive owner of each and every bit of the new code, including the portions of the code that they had copied, previous existing code from that base code. That's a very different thing. And actually, if I could just quote the provisions of the district court's opinion, where it's relying on an exclusive license code in order to grant, or a non-exclusive license, but in order to grant exclusive ownership, the court said, here it is enough to note that having created the base code in 2008 makes no difference for the purposes of Apprio's rights under paragraph 2.2. That may well be true, but 2.2 is not, it's a non-exclusive license is what it grants by its plain terms.
What do we do with the fact that the company asked him whether or not there was this was a derivative work, or there was any works that he was claiming copyright ownership of, and he did not identify in such?
Yes, Your Honor. I think you're referring to 2.2's requirement to disclose prior inventions, and he didn't fill that out.
I mean, how is the railroad supposed to run, so to speak, if given that opportunity to identify any prior work or any works that you're saying that I intend to retain the copyright of this, and it's not, I'm not using it as part of my work for you. I developed this before I worked for you, and I have a copyright in this that I want to retain. You're given the opportunity to identify that, and you don't.
Yes, Your Honor.
It seems that that's the whole point.
Well, it certainly might have implications for 2.2, but importantly, the language of 2.2 is pretty clear. The first sentence says, inventions, which I made prior to the commencement of my service, are excluded from the scope of this agreement. Later, it defines a term which is required for a prior inventions disclosure, but notably, there are multiple requirements to qualify as that. So we would argue that doesn't qualify as a defined term within 2.2 of a prior invention, because it's not just an invention that was made beforehand. It also it's required that it's one that will be used in your service with the company. Mr. Mr. Zaccari wasn't a software developer here. So this wasn't something that was within the service.
So the district court found that this was used, the district court made a finding that this was used. Are you saying that that finding was clearly erroneous or that somehow we're supposed to overturn that finding?
The legal error is that even if he failed, even if that were an okay finding, and even if he failed to disclose on this prior invention form, it just doesn't change the fact that when you read the contract, 2.2 is granting a non-exclusive license. So even if the failure to disclose has an implication for 2.2, at best, it's going to get you a non-exclusive license. It's not going to get you an exclusive ownership, which is what they saw in their receipt below.
Any questions? All right, thank you. We'll give you some time on rebuttal.
Thank you very much, Your Honors.
Good morning, Your Honors. John Hutchins for Apprio. So the CRR software was created in 2016, and that was admitted both in request for admit and in the answer. Paragraph 40 of the answer affirmatively states by Mr. Zaccari that the CRR software was created, quote, during the time period he was also an employee of Apprio. Full stop. Since the CRR software was created in 2016, admittedly, and of course, Your Honor is correct, copyright applications and copyrights themselves provide date. Here, the date was 2016, also provided by Mr. Zaccari. The copyright's at 692 and the application's at 950. Having been created in 2016, admittedly during the time of his employment, it was an assigned invention under section 2.3. 2.3 assigns any inventions created or reduced to practice during the period of employment, whether registrable or not. So I think the notion of which portions are or aren't registrable for copyright, bit of a red herring. What's important, it was created in 2016, and admittedly so. Yet another reason it can't be a prior invention subject to any exception of section 2.2 is that no prior inventions disclosure form is filled out. Also, admittedly so. While I'm discussing admissions in general, whether a work is derivative or not is absolutely not a pure question of law. In fact, it's a question of fact. And I'll cite to you Folio Impressions versus Bayer, 937 F. 2nd, 759, and Atkins versus Fisher, 331 F. 3rd, 988. It's a perfectly appropriate admission that we're entitled to rely upon. So for all of those reasons, section 2.3 assigned the rights. And that's all the district court appropriately held. He also noted, as I just explained, section 2.2 could not apply, both because it wasn't a prior invention, because it was created in 2016, admittedly, and because it wasn't disclosed as it would have had to have been. And as to the issue of whether it was used in connection with his work, district court's opinion and the admitted facts he relies upon speaks for itself. Mr. Zaccari, by his own telling, was working on a project for Apprio for the government to render their contract review more efficient. He created this software, he says, because he knew it would be useful. He brought it in to show to Apprio and Apprio's customer. He admitted the only reason he had access to Apprio and Apprio's customer and was able to do that was because of his employment. And then he states that Apprio told him to provide it to the government as a condition of his employment. And he did so and kept his job for the remaining 10 months till the contract ended. That describes use in connection with your employment. by definition, I would submit.
Can I ask about the contract formation issue? And I
Certainly.
think you're on very strong ground there, but I just want to kind of play it out a little bit. Let's imagine that instead of making the admissions that you're suggesting Mr. Zaccari made, that he had said deny, deny, deny. You could acknowledge those denials without agreeing with them, correct?
To say the last part of the question again, sir?
You could acknowledge his denials without agreeing with his denials, correct?
Yes.
There's a difference between acknowledging and agreeing.
Theoretically, there could be.
Like if I said to my friend, "Hi, Jackson, the weather's nice," and he acknowledged my greeting, it doesn't mean he's agreeing with me that the weather's nice, correct?
Theoretically, that's absolutely the case.
What's different here? What about the context here makes it different?
Because the context here is that under DC law, contract formation requires no specific magic word of I agree versus I assent versus I accept. Accept, which was admittedly used in the Forrest case. That was the fact scenario in the Forrest case where the court held contract formation. I assent can mean I agree to the contract. It could mean I assent that I received the contract. The Metropolitan case, which held that copyright assignments can be electronically assigned. The court discussed yes. There is no difference in kind between agree, accept, assent, acknowledge, yes. And DC law is crystal clear that what matters is the objective manifestation. What Apprio requested happened in this case to say acknowledge. And he acknowledged it.
Was there some benefit to using the word acknowledge there as opposed to agree, or were they just the same and either one would have worked just as well?
Either would have worked just as well. I mean, so when when this issue came up, I actually cracked open my Black's Law Dictionary, which it had been about 30 years. When I went to law school, it was given to me as a gift, as many law students get that as a gift. And acknowledge means to accept responsibility for, in general. So I think that there's nothing wrong with acknowledge. I'll also note that the term acknowledge also has been used for contract formation in exactly this scenario where an agreement is pulled up, you see the agreement, and you click acknowledge. That's the Fox versus Computer World case, which was cited to the district court in this matter, 920 F sub second 90. And there, an employee was being onboarded, and he pulled up all the various onboarding agreements for his employment, one of which was an arbitration agreement. And he acknowledged it. And the DDC had no problem holding that acknowledging their manifested contract formation. But even if one were to quibble about that, and I don't think the law of DC and contract formation requires you to say, I agree to the agreement, versus I acknowledge I agree to the agreement, or I assent or yes. He has other objective manifestations, such as the 10 months he continued to accept consideration. And under DC contract law, DC allows for contract formation when a party accepts the consideration.
What's the consideration for the assignment?
The 10/12ths of the $150,000 he was paid for the ensuing 10 months.
But he doesn't get any separate consideration for any sort of a license? Because
No.
it's assigned.
No, that's correct.
So he gives up all rights and earns no royalties whatsoever on his creation.
Just his salary, which I say just, I mean, he was salaried at $150,000 a year as a senior technical manager. And that's the case whenever, I mean, that's no different than whenever these company agreements go into effect. And the consideration, by the way, is set out literally in the opening sentence. The title of the agreement is bold in caps saying it's an inventions assignment agreement. Immediately under that, it explains that the consideration is his being retained as an employee and receiving his
So I
salary.
remember right that he tried to use this agreement against you?
Well, that's the third manifestation of assent objectively is that he hired a lawyer and brought suit to enforce the agreement in federal court. And that's a pretty strong objective manifestation that he intended to be bound, bringing a federal lawsuit to enforce a contract. And I'll go so far as to say that I'm certainly unaware of any case. I'm aware of a ton of cases that hold that the clicking the acknowledgement would have been enough. I'm aware of a bunch of cases saying that remaining employed for the 10 months and accepting the benefit would have been enough. And I'm unaware of no case in which someone attempted to enforce a contract and then was able to claim a secret subjective intention to not be bound that was later recovered in memory trumped. Because if that were true, no contract known to man would ever be safe. And of course, that's not what DC law is extremely clear that it goes full bore into the objective theory of contract law. Unless your honors have any other question, I appreciate your time and I'll conclude. Thank you.
All right, thank you. All right, we'll give you 2 minutes for rebuttal, Mr. Keenan.
Thank you very much, Your Honors. Just say quickly, to affirm beyond the interpretation whether or not a copyright was even transferred or what scope of copyright was transferred into this, we'd still have to affirm on both formation and Section 204 signature requirement. So just quickly, Section 204 requires any time a copyright is transferred, there's a signed requirement. While the e-sign Act doesn't put electronic signatures on different footing, I don't think if we use paper and pen to just check something that said acknowledge, that would satisfy the ordinary meaning of signature. So it's not clear that regardless of the formation question, this satisfies Section 204's signature requirement of the Copyright Act for a transfer. Beyond that, I just want to reiterate that the Supreme Court in Feist said that there was an important limitation on the protection of a copyright. The mere fact that a work is copyrighted doesn't mean that every element of that work is copyrighted. What's required is originality, and originality means not copied from something else. Beyond that, regardless of whether or not it's a derivative work, there's multiple provisions of the Copyright Act that are violated by essentially saying that this transfer under 2.3 transferred each and every component, including the copied components of the prior code. Section 102A is originality requirement, Section 103B, which makes clear that pre-existing materials that are copied don't extend to the derivative work. And that's the only one that's affected by it being a derivative, not Section 102A is originality, 201D2 is divisibility. And finally, I think it's important that when he was fired, ultimately, ironically, he received a termination letter that asked him to, and it's at 3JA608, to acknowledge, it's an acknowledgement signature. So one thing that's important on the formation question is that the record shows that this company had made employees sign not just contracts, but also policies where they would acknowledge things. And even when he was fired, it required an acknowledgement signature, which I don't think was forming a contract. So I think there is a distinction between acknowledge, agree. Thank you very much, Your Honors.
Thank you. We'll take the case under advisement.
Case number 22-1308, Johannes Lamprecht and Linda Lamprecht appellants versus Commissioner of Internal Revenue. Mr. DeVos for the appellants, Mr. Brandman for the appellee.
Morning, Mr. DeVos. Certainly.
May it please the court, good morning. My name is Lloyd DeVos, and I'm counsel to the appellants, Johannes and Linda Lamprecht. And I'd previously requested 2 minutes be set aside for rebuttal. I'd like to direct the court to the fifth argument in our brief, that the final resolution of the UBS John Doe summons took place on August 19, 2009, when the United States and Switzerland agreed
Can
in
you move
paragraph.
the lectern up a little bit because the microphone is not catching everything.
Up.
Up.
That went down.
I'm sorry, Your Honor. I'll start again. I'd like to direct the attention to the court to the fifth argument in our brief, that the final resolution of the UBS John Doe summons took place on August 19, 2009, when the United States and Switzerland agreed in paragraph 3 of the agreement between them that the UBS John Doe summons would not be enforced. August 19, 2009 is the date when the UBS John Doe summons was resolved, and not at a later point in time when the commissioner, for reasons known only to himself, sent a letter to that effect. Even with extensions of time as provided by law, the limitations period for the commissioner to issue notices of deficiency had expired prior to the deficiency notices being issued to the Lamprechts. Even if you agree with the commissioner, which you should not do, that he met his burden of production under sections 7491C and 6751B by having an immediate supervisor approve in writing the accuracy penalty that we're discussing here under the applicable legal standard. And even if you agree with the commissioner, which you should not do, that the Lamprechts did not file qualified amended tax returns after the commissioner issued the John Doe summons, notwithstanding the fact that they made no claim on their original return with respect to the activity described in the UBS John Doe summons as is required in the Treasury regulations. And even if you agree with the commission, which you should not do, that the UBS John Doe summons was a valid and enforceable summons, notwithstanding that the only evidence produced below proved that the UBS John Doe summons was not issued for the purpose of obtaining documents and information under section 7602, but was issued for the prohibited purpose of extending the statute of limitations and as an illegal summons and not be relied upon to extend the limitation period during which the commissioner could claim a deficiency from the Lamprechts. Even if you agree with the commissioner on all these things based on the agreement between the United States and Switzerland as two sovereign nations, the time for the commissioner to issue a deficiency notice in respect of 2006 expired on November 11th, 2013.
Why should we accept that date rather than the date that the subpoena was complied with?
Because at the time the United States and Switzerland entered into the agreement that they did, they agreed that the subpoena, that the UBS John Doe summons shall not be enforced by the United States, not will not be enforced, shall not be enforced. That's an agreement between two countries pursuant to the mutual agreement provisions of the agreement of the tax treaty between the United States and Switzerland. As such, it has binding force, and the United States agreed it was not going to enforce 7602 or attempt to enforce under 7602 its right to obtain documents using the subpoena power. The United States agreed that with Switzerland. And therefore, it's not a question of when it's complied with. The United States agreed that it is not going to attempt to obtain compliance. And at that point, we're done. The subpoena has been resolved using the language of—
How is that consistent with the statute?
The statute says when it is final, when it's finally resolved, when the commissioner has determined that the subpoena has been finally resolved. That's what the regulations say, finally resolved. The agreement by the commissioner that the UBS John Doe summons was not going to be enforced resolved the subpoena, it resolved the summons. The summons at that point in time was not going to be ordered to be enforced by a federal court. And as we've said in our brief, where you have.
What if someone issues a subpoena to another party for documents and they reach an agreement like this that says we're not going to enforce, but they say, we're not going to enforce the subpoena, through contempt or otherwise. But if you don't give us the documents within 30 days, you agree to pay us essentially liquidated damages of $1 million. Has the subpoena been resolved? Has it been complied with? If that's the agreement?
No, I would say in that circumstance between private parties, no, Your Honor. But here we're talking about an agreement between two sovereign nations having force of law under the mutual agreement provision of a tax treaty. And as such, it does resolve the subpoena, because we're talking here about an agreement that this subpoena has been resolved. There's no condition that I'll pay you $1 million later.
Well, there's a condition that you're going to get documents, right?
No, that's
I mean,
the
that was part of the agreement.
No, Your Honor,
That
that was,
documents are going to get turned over.
no, Your Honor, that was part of the UBS agreement with the United States. The agreement between the Swiss government and the United States was that the subpoena will not be enforced because the parties had different interests. And that's why there were two separate agreements.
Well, who was the subpoena issued to?
Subpoena was issued to UBS. But the government of Switzerland intervened because its interests as a sovereign were being affected. What was happening is that the United States, through the issuance of the subpoena, was asking UBS to violate Swiss law. And the Swiss government had issued a blocking order prohibiting UBS from turning over any documents to the United States or to the IRS, regardless of the order of the district court.
And the way that it got resolved was that the United States would not enforce the agreement against Switzerland, but that UBS would turn over documents, and that's what happened.
No, Your Honor. The way it got resolved was that the United States made a request for documents under the tax treaty between the United States and Switzerland. The Switzerland received the document information request, and Switzerland, using its domestic law and internal law, requested the documents from UBS. UBS turned the documents over to the Swiss Federal Tax Administration. And the Swiss Federal Tax Administration then turned the documents over to the United States pursuant to the terms of the tax treaty. There was no direct disclosure of documents from UBS to the United States. That did not take place. And that's also important in the context of the extension of the statute of limitations, because if the United States is receiving documents under a valid IRS summons, the statute of limitations may be extended. That is not the case in the case of a document.
Is there a formal request by the Internal Revenue Service for documents pursuant to the tax treaty?
Yes, there was, Your Honor.
And is that in the record?
No, it is not, Your Honor. It was not relevant in the court below.
If the request simply said, please turn over the documents that are covered by our John Doe summons.
I'm sorry, Your Honor, I don't understand the question.
If the document request simply repeated the John Doe summons, then your argument seems to me to evaporate.
Your Honor, the document request that was made by the United States to Switzerland was a different document request that did not reflect the document request under the John Doe summons.
What were the documents that the United States was asking Switzerland to turn over, or UBS to turn over? How did they differ from what the John Doe summons sought?
The reason, Your Honor, is because, and it's parts of this are in the record in the form of the excerpts from the Swiss government official report. The difference is that the Swiss government objected to a blanket summons as not being authorized under the tax treaty. The summons was tailored pursuant to agreement between the United States and the Swiss government to only require certain categories of information from people who had bank accounts of greater than a certain size, which met the indications of fraud or the like under the terms of the United States-Swiss tax treaty. And again, none of this was
Well, if it was narrowed, it was still part, I mean, that sounds to me like that was part of the John Doe summons.
Well, Your Honor, it's part of the documents requested under the John Doe summons, but as a matter of law, it is not the John Doe summons. It is a tax treaty request, and that is a different legal animal.
Well, they can compromise and agree on narrowing, and when the documents do come in, pursuant to the compromise, then the John Doe summons has been satisfied. And that's I think that's the Internal Revenue Service's take, that resolved means satisfied.
I understand your point, Your Honor, but I respectfully disagree. The government of Switzerland made it very clear in their submissions, and as you can see in the Swiss government official report, that the Swiss government objected to the infringement upon their sovereignty of the issuance of a John Doe summons by the United States. They said, then they issued a governmental blocking order prohibiting compliance. The Switzerland said that the only way that they were going to permit the documents to be given was pursuant to a request under the tax treaty, which did not violate their sovereignty, and which they had agreed to provide documents under. But again, that's a different type of a document production than production under a summons. The Internal Revenue Code specifically says that there's an extension of time for the statute of limitations in the case of a summons. It does not say, and it specifically does not say, that there is an extension of time in the case of a document request under the provisions of a tax treaty request. And that's how we understand the tax law to be. There's never been it's become almost a matter of faith among the tax bar, but there are no judicial decisions on it one way or the other.
I understand. Thanks.
Do you agree with this statement? The settlement agreement between the parties to the enforcement suit specified the dismissal of the suit would in and of
I'm sorry, I'm not hearing you. I apologize.
The settlement agreement between the parties to the enforcement suit specified that dismissal of the suit would in and of itself have no effect on the John Doe summons.
I agree with that, Your Honor. As we said in our papers, it had no effect whatsoever. There was no determination whether the John Doe summons was effective or was not effective. The parties agreed to put that off for a later day. And as it turned out, it was never an issue that came up.
I'd like to turn to the first argument in your brief, which is where I thought you were going to begin your oral argument. And I think there's some strength to the merits of it, that 6662 lists about 10 different penalties, about 10 different accuracy-related penalties. And the supervisor here, when he gave his approval to assess a penalty, didn't specify which of those 10 accuracy-related penalties he was approving. But the the tax court did not address that argument one way or the other. Were you surprised that the tax court didn't address that?
Yes, Your Honor. I was surprised for a couple of reasons. One, because the assumption in your question is that the supervisor approved the penalty, whereas we pointed out in our brief, the signature of the supervisor happened before.
No, I want to not get too distracted by the other arguments.
Okay.
In this
particular
argument that you make on approval,
because the tax court in 3 separate cases has said you have to specify the penalty, and the leading case on which the other tax court judges reside, was the decision of Judge Gustafson in.
If you were surprised the tax court didn't address this point, why didn't you move for reconsideration on it?
We didn't move for reconsideration on this point because, frankly, after reading the opinion, we didn't think we would get anywhere.
Well, I think maybe that was a reason, but maybe another reason is that you hadn't made this argument before the tax court. So it actually shouldn't have been very surprising that the tax court didn't address it.
No, Your Honor. As we put into our brief, we did specify this in our last reply brief that was filed with the tax court. And in fact, I quoted the provision in the brief where we actually raised the argument to the tax court.
So even if raising a new argument in a reply brief on a summary judgment motion is enough to put an argument before a court, your argument, and I've got it here in front of me, very skeletal. It says, Mr. David and Mr. Anderson say what they say. They approved the initial determination without knowing what the penalty was, the authority for the penalty, or how much the penalty was for. The declarations are not evidence of a written initial determination to impose a penalty. That doesn't sound very much like the argument I summarized, and it doesn't sound very much like the argument that you make in your blue brief here.
Well, Your Honor, I think that all I can say to that is the way that this case developed on the motion for summary judgment was that we received copies of the documentation on which the government relied as part of their motion for summary judgment. They were not produced previously in discovery. We received the explanation of those documents in the government's reply brief.
Right.
When we
Did-
reviewed
did
the
that-
government's
You
reply
mean the
brief-
government's response to your summary judgment motion?
No, in support of the government's summary judgment motion.
Did that come before or after you filed your reply brief in your summary judgment?
That came before we filed our
Why
reply.
couldn't you make this full argument in the reply brief to your summary judgment motion?
The answer, Your Honor, is because we were limited by space in terms of what we were doing. There's no other reason for it, and I can't give you one.
Okay, and I do think that goes back to the I'm not an expert in tax court procedure, but you can file a motion for reconsideration to a tax court decision, correct?
You could, of course.
Okay.
Under the rules.
All right. If no other questions, we'll give you some time on it.
Thank you very much, Your Honor.
Mr. Brandman?
Please, the court, Robert Bramman for the Commissioner of Internal Revenue. At bottom, this case is very simple, or at a superficial level, this case is very simple. The Lamprechts filed a tax return, and then a few years later, after on which they did not report their Swiss bank income. A few years later, after a widely publicized U.S. government crackdown on Swiss bank secrecy, widely publicized at least amongst tax attorneys and Swiss bankers, they filed amended returns. It's perfectly obvious from comparing, if the amended returns are correct, perfectly obvious that they understated their income by more than 5,000 and more than 10%.
You're saying the UBS summons, the John Doe summons was widely publicized?
I am saying it was widely publicized. At least the government crackdown was widely publicized.
Before the taxpayers filed their amended returns?
I think it was, but it's not essential that they have known about it.
Right, yeah.
The
Because the way I read the regulation, what matters is the date of service.
yes, that's right. I'm just given some background just to make it more of a narrative. Sorry. In any event, if the amended return is correct, the original returns plainly understated income and they're liable for this penalty. And beyond that, we have sort of a buckshot approach to many different theories for why the assessment might not be correct. And rather than march the court through my refutation of each of them, as I did in 60 pages of brief, I'm really only interested in whether the court finds any of Mr. DeVos's arguments compelling.
Well, I raised get my numbers right, the 6751 argument.
Yes.
And, I asked some questions of opposing counsel that, suggest I think it may well have been forfeited here. But you represent the government and you will have more cases, and at some point an attorney is going to nod for this argument. So when an approval, a supervisor's approval of an inspector's proposal for an accuracy-related penalty just says, I approve accuracy-related penalty, i.e. I approve 6662 penalty. How is that approval of the relevant penalty when it could be any of 10 6662 penalties?
It's not that specific, correct? This has been a developing area of the law in the last 10 years. So
Sounds like it's developing slowly.
it's been developing. So there was no development for a long time after the statute was first enacted, I think in 1998. And development started to pick up around 2015 or so. Tax court started taking that provision seriously. If I am correct, the Treasury is currently writing some regulations that will hope to, bring some certainty to this area. But to this point, it's only been a common law series of tax court decisions, looking at this issue tangentially And none of them really support the point that the approval has to specify the subsection of 6662. In order
Just to be clear, I don't think that the strongest argument is that it has to name the subsection. I just think the argument is it has to make clear which of the subsection penalties it's approving it. In other words, if one subsection were called the inheritance tax penalty, then, and that was subsection H, you know, I'm not saying that it would have to say, I approve a subsection H penalty assessment. It could say, I approve an inheritance tax accuracy related penalty assessment. Right.
Currently, the overall section is just called accuracy related penalty. There are, I think, 10 different provisions that allow for 20% penalty, and they're not stackable. So they can't be, the penalty can't be more than 20%, even if, you know, multiple. Some of them hold a larger penalty, 40% or 50%. I think it would be, there'd be a distinction there. Perhaps if the approval is for the 40% penalty, it should specify that it's that level of penalty or the subsection that imposes a penalty at that level. But among the 10 or so that only impose the 20% penalty, at least among the 2 or 3 that are most common, it's, well, so far no court has held that it was necessary to pin that. And there's no, there's not a handle, I think, in 6751 that indicates that it should be.
Well, I mean, get the number right again. 6751 talks about such assessment. So it seems like it's referring to a particular assessment. And it could be that you look at returns and it's possible you could do an assessment for a negligence accuracy related penalty or an underreporting accuracy related penalty. And if the supervisor just approves, choose your own adventure, inspector, pick whichever accuracy related penalty that's at the 20% level you want, then it's not really the supervisor approving such assessment. It's more like the supervisor giving the inspector something close to a blank check to, I approve now, and you decide what I'm approving later.
In this case, at least, I think the approval for substantial understatement penalty should be the easiest one, should always be included. In this case, you can look at the 2 returns and it's perfect. You don't have to turn past the front page of either of them.
But in this case, there was later a negligence accuracy related assessment.
Yes,
right?
there was.
So that was possible. Underreporting was possible.
There was a later approval of the negligence penalty after the examination, I guess, maybe did some additional work. But just simply on opening up the thing, an examiner can look at the front page of 2 returns and know like that the substantial understatement penalty clause.
I don't know if I understood. Are you saying there were 2 approvals?
Yes, there was a later approval for negligence penalty.
For the exact amount of the assessment?
The approvals don't specify the amount.
It was what?
Well, the negligence penalty is
Oh.
the same 20% as the substantial understatement penalty. There was a later approval submitted by a different revenue agent for negligence penalties, and they were approved. They were communicated to taxpayer at a later date.
There's been a great deal of discussion in the press about the IRS backdating these approvals. Is that an issue here?
There's not an issue about backdating of the negligence penalty or the approval of the substantial understatement penalty. There's been argument in this case about what time of day the revenue agent signed off on the initial determination versus when the supervisor signed off. My opponent, my friend, has argued that the supervisors approved before the revenue agent signed. Tax court said the revenue agent doesn't have to sign at all, so it doesn't matter. But as to the specific issue about what time of day the approval came through, I put those approvals under a virtual microscope.
This was not is this a form that the supervisors sign, or does the individual revenue agent prepare this, whatever this form, and give it to the supervisor?
This was a form the revenue agent prepared in order to get permission to open up the 2006 and 7 years. The revenue agent was already examining 2010, and he requested the earlier returns in order to complete his 2010 examination. And he saw that 2006 and 7 could be penalized. So he requested permission to open those returns up in order to assess an accuracy-related penalty.
Okay.
The supervisor signed off, and according to Mr. Voss, the revenue agent signed later in the day. But I expanded those forms on my computer to 300%, and I couldn't see the time of day that the revenue officer signed off. But the best answer is the tax court's answer. It doesn't matter whether the revenue agent signed them all.
Do you want to respond at all to the argument number 5 that your friend on the other side made, that the date that the agreement was reached between Switzerland and the United States, the summons would not be enforced, should be the controlling date?
I think I heard some new material today. This phrase that the parties agreed the summons would not be enforced. I don't think I saw that in the briefing before. But of course, the case below was not about enforcing the summons or about a document request made by treaty. That's just part of the background. In fact, the important part is that the IRS issued a summons, and the statute is extended based on the final resolution of the summons. Is either, if it's been enforced, one set of dates. If it hasn't been enforced, when the summons is finally resolved. Regulation gives that date as when all the material has been turned over, and it even gives the IRS an additional amount of reasonable additional amount of time to review the material that's been given its complexity and volume, to determine that the summons has been complied with. And there was agreement all around between Switzerland and the IRS as to when material was turned over, and November 15th of next year.
All right. There are no other questions. Your argument submitted.
Thank you for your time.
And Mr. DeVos will give you 2 minutes for rebuttal.
Thank you very much, Your Honor. Let me speak first to Judge Randolph's question. The IRS has a Form 300. There is a copy of it in the record. It's referenced in our briefs. The IRS Form 300 is a civil penalty approval form. Whenever an IRS agent wishes to propose a penalty against a taxpayer, the Internal Revenue Manual, which of course is not legally binding, says that the IRS agent should fill out the form, submit it to his supervisor. The supervisor signs off on the form. The penalty is approved, and then it's communicated. All of these 6751B cases, not only this one, but all of them that are making their way through the courts, all involve the situation where the IRS agent did not fill out the Form 300. In other words, they took some other approach to trying to get supervisory approval, or they did not get supervisory approval at all. That's the evil that 6751B was aimed at. And that's why we see a lot of cases coming through the tax court and coming into the courts of appeal now on this.
Are there any other cases, I'm not clear about this, are there any other cases in the federal courts, not the tax court, that deal with this particular form as a method of satisfying supervisor approval?
No.
How about in the tax court? Besides,
Not that I'm aware of in the tax court, Your Honor. No. The only other point that I'd like to make to the court is that normally taxpayers have great difficulty in proving the institutional intention of the IRS. And you can't make a claim that the IRS behaved wrongly. This case is very unusual in that because of the affidavit of Dr. Zulov and the official Swiss government report, we actually have evidence of the institutional intention of the IRS. The IRS said to their Swiss counterparts, we're issuing the UBS John Doe summons in order to extend the statute of limitations. A few days after that, the IRS went into district court and filed declarations saying we want information and documents. Both can't be correct at the same time.
Do we know whether, what material, if any, accompanied the form when it went to the supervisor for approval?
We have no information. In other cases, the IRS has submitted an affidavit of the agent who submitted the form, for example, and that's referenced in our brief where the agent submitted an affidavit saying what information was submitted and what he was relying upon in order to get, and what the process was to get the supervisor's approval. In this case, the agent is still in the employ of the Internal Revenue Service. There was no affidavit submitted.
We don't know whether any information other than the form was put before the supervisor.
We don't know. We don't know. That's within the purview of the IRS, and we were never able to obtain that information.
I meant to ask you one question about the qualified returns issue before now. So, but I'm
Thank you, Your Honor.
The original tax returns asked if you had any foreign bank accounts, and your clients checked no. And then later, for the corrected returns, they checked yes. So
That is correct.
So my question is about the original returns. When they checked no, wasn't that an affirmative misstatement?
That was an affirmative misstatement if you assume that it was affirmatively done, and we could get into that. But there have been cases before the various district courts and courts of appeal.
I don't understand what you mean. You said it was an affirmative misstatement if we assume it was affirmatively done.
I'm sorry, Your Honor. I'm trying to clarify. The software that accountants use to prepare these forms default to a no answer. There have been cases in the district courts, and I don't think there have been any in the courts of appeal, in connection with foreign bank account report forms, where the taxpayer has said, I didn't affirmatively intend to check that box. The software did it, and I didn't notice it. That issue never arose in this case.
And the precedents say when that happens, we don't blame the taxpayer?
The district courts have held that this is a question of fact, usually in the context of whether the taxpayer willfully intended not to have the box say no or not. There was no finding on this issue. There was no fact finding on this issue that took place before the tax court. But yes, I agree with you. The original tax return that was filed did indeed say that there were no foreign bank accounts, and the amended tax return did indeed disclose all of the Swiss bank accounts.
Thank you. We'll take
Thank you very
that
much.
under